this is Cliff Brooks with National Lien Law, and this is part 1 in a part 3 series of how to file a California mechanics lien. In other videos, we will be talking about design professionals, including architects, engineers, and land surveyors. So this video will only deal with general contractors, subcontractors, and equipment or material suppliers. We have a lot to cover, so I'll start right away with hitting point after point. But remember, this article has been put to writing and is on one of our blogs at National Lien Law, our website, for your reference. And anyone can email us and you'll get a full California Lien Law summary for free. The email address for us is info.nationallienlaw@gmail.com. So let's get started. In the United States, mechanics liens go back to 1791 in the state of Maryland, which was given to contractors to ensure they were paid in building the capital city of Washington, D.C. From the beginning, they constituted a lien on the property, just like a mortgage. The effect is to prevent the sale or refinance of the property unless you are paid. So it's a very powerful device. But in exchange, the courts insist you follow the right procedures and record on time, or you lose those rights. For this reason, they are very picky as to the technicalities. As far as who may record a mechanics lien, the California legislature has opened the doors wide and allows it for any person or entity who contributes labor, equipment, or materials that are used, consumed, or incorporated into the construction project and permanently improves same. Other than the obvious examples of prime contractors, subcontractors, and suppliers, liens can be filed for and by machinists, house movers, labor pool companies providing labor services, grading, leveling, and filling, demolition, removal of trees and other vegetation, drilling test holes, sewer and utility construction, providers of temporary and permanent power, construction of vaults, cellars, or rooms underground, union fringe benefit payments, and off-site street and other utility work. As a matter of fact, new California Civil Code Section 8022 now allows a lien for persons who furnish, quote, supplies, appliances, or power. It sounds pretty expansive, doesn't it? Well, that's because it is. However, by definition, there is no lien for such persons or entities as building permit expediters, soil preparation work for landscaping services, such as disking or rototilling, companies that sell as opposed to rent equipment to a contractor, supplying tires on rented equipment, selling materials or equipment as opposed to rental, temporary fencing, portable sanitation, lunch wagons, construction payroll services, construction software providers, real estate brokers, and others who do not provide any services or materials consumed in the construction. As mentioned above as to who may file, it applies generally to contractors and suppliers. As a contractor, however, you have to be currently licensed to file the lien. The California mechanics lien form itself does not require, unlike other states, that you insert your license number in the form, but you are not allowed to collect money or file a lien without the license, and it can be grounds for discipline through the California Contractor State License Board. And the general contractor cannot file a lien for the portion of the work that is subbed out to an unlicensed subcontractor. But the reverse is not the case. Subs and suppliers get a mechanics lien even if their contract is with an unlicensed general. You should be licensed for all times during the job, but if you inadvertently fail to register your license, you can argue there has been what is called substantial compliance. But you never know what the judge will say. Under California Business and Professions Code Section 7031B, the owner can now sue you to recover back all monies paid if you were an unlicensed contractor. So be very serious about this. You can be an individual doing business under a trade name or a corporation or LLC or even a partnership. Although it might be a good idea to have a corporate resolution, this is not required before recording the lien. You have to change or improve something, not just maintenance. In most cases, it would not be a problem proving this because the construction services are causing improvements to the property. But assume you're only replacing fluorescent lighting in the hallways of an apartment complex. Replacement alone is not an improvement, but if in the process of replacing you reinstall or repair some of the defective lighting boxes, it would be lienable. Or if you're a landscape company and are simply mowing, watering, or fertilizing the plant material, that is not lienable, but you can file a lien for the initial planting, installing an irrigation system, or putting in retaining walls, as you're making improvements. Other examples of lienable work would be janitorial cleanup of the construction project or trucking services where you're hauling away soil or debris. Unlike the federal Miller Act project or act where you only can be a first or second tier subcontractor, you can file a claim of lien in California literally as a sub of any tier, and you still get a lien. But you cannot be a material supplier to another material supplier. For example, a sawmill supplying lumber to a supply house. The supply house gets a lien because they are providing material usually to a contractor. The mechanics lien in California is against the owner's title to the property. And if you are a sub or supplier, it is not against any of the property owned by the general. For tenant improvement work, your lien is against the long-term tenant's interest. And this consists, believe it or not, there's some value to this. This consists of the value of the lease and the trade fixtures. Technically, on foreclosure, the trade fixtures can be sold off and removed from the property as long as it does not cause material damage. The good news is that in almost all long-term commercial leases, there is a clause that says it's a default if the tenant allows the mechanics lien. This in turn puts pressure on the tenant to pay because the landlord will start screaming at them to make sure the balance is paid. You can file a lien if your contract is either verbal or in writing. The statute of frauds, which requires certain contracts to be in writing, does not apply here. And the Uniform Commercial Code is also inapplicable because you are providing construction services and not simply goods. In other words, you are providing both materials and labor. But if you are solely a material or equipment supplier, the UCC does apply, and your contract or purchase order should be in writing. The big exception is residential projects. The California Business and Professions Code requires, as a condition to file your lien, that you have a written home improvement contract, which has almost 21 separate provisions. But obviously it's a good idea to have all your contracts in writing anyway. Judges do not like oral contracts because of all the uncertainty. If you do have a written contract or purchase order, make sure both parties sign. National lien law has seen so many cases over the years where a signature is missing and therefore the written contract is no longer binding. Change orders, they occur on every project, right? Include in your mechanics lien the amount of all change orders or extras, whether signed or not. If you've been directed to do the work and do so, that is sufficient for your lien. As we all know, it is common for architects, construction managers, and other representatives to tell you to do the work, promise to sign a change order, but it never comes. In the meantime, you have performed the services and relied upon those representations. Many contracts say that you do not get change order work unless it is reduced to writing. However, under the principles of waiver and estoppel, if you are directed to do the work and either side refuses to sign the change order, you can lien for that amount. As far as the amount of the mechanics lien, it's the labor, materials, and equipment actually furnished up to the time of the lien. Technically, the code indicates the reasonable value of which you have conferred, but in almost all cases it is based upon the contract amount furnished to date. But what if you've been terminated or have temporarily demobilized for a non-payment? You don't get the balance of the contract or future lost profits, but only what you have conferred thus far. So if you have a $100,000 contract and you've been terminated after 80% complete, you only get $80,000 even if the other side has breached the contract. The other $20,000 cannot be in the mechanics lien. However, when you bring a lien foreclosure lawsuit and add to it causes of action for breach of contract and unjust enrichment, you can add that $20,000. Include all amounts and do not discount for what the other side is alleging. So if you're a sub and have a $20,000 bill, but the general contractor claims you're only owed $15,000, it's what you think, not what they think. Add everything you think you're owed. As far as punch lists and allegations of deficiencies, the other side can only withhold under industry standards 1.5 times the alleged damages. So again, if you're owed $20,000 and the other side says it will cost $1,000 to correct the punch list, they can only withhold $1,500. They cannot withhold the whole $20,000. Although there's no statute or case law on this, this is usually the rule applied by arbitrators. The lien amount can only be for the raw principal owed. When you go to court with a lien foreclosure lawsuit, you also get finance charges and/or prejudgment interest, as well as court costs and attorney's fees. So your lien itself should just have the principal amount and have the phrase, in addition, prejudgment interest and court costs and attorney's fees according to proof at trial. So that's it for this segment, and we look forward to talking to you again on part 2. Thank you very much.